For years, we were told to accept a grim trade-off if the government waved the banner of public safety. Your right to carry could be fenced off, boxed in, or switched off at a state line. That weary script is cracking. Courts are finally saying what millions believed all along: constitutional rights do not vanish because a map changes color. That is not spin. That is the legal reality taking shape case by case, ruling by ruling. And it feels like a long overdue correction. The turning point was the Supreme Court's Bruen decision in 2022. Instead of rubber stamping restrictions under a fuzzy two-step balancing test, Bruen demands history and tradition. If a modern rule lacks a relevant historical analog, it cannot ride on vague promises of safety. That standard is simple, principled, and powerful, and the ground is shifting under every courtroom that applies it. Show the history or the law falls. That clarity unleashed a wave of hard looks at rules that once hid behind rhetoric. One of the biggest pressure points is residency walls, rules that tell peaceable adults you can't even apply because you live somewhere else. That mindset treats state borders like magic erasers. Under Bruen, judges are cutting through that fog. In California, a federal court in Hoffman v. Bonta concluded that flat categorical bans on non-resident carry applications are inconsistent with the Second Amendment's text and tradition. That is huge. It does not create constitutional carry everywhere, and it does not create national reciprocity, but it slams the door on the laziest barrier of all. You are from out of state, so you are out of luck. Feel the practical impact. When a state runs a licensing system for its residents, fairness means opening the same path to qualified visitors, same background checks, same training, same standards. That is common sense finally aligned with constitutional sense. Travelers, caretakers, small business owners, and military families know the old anxiety of crossing a bridge and losing lawful status mid-drive. Every time a court tears down a residency wall, that anxiety shrinks. That is a win you can feel in your shoulders in your planning, in the simple relief of consistency. None of this erases neutral screening. Competence tests, fingerprinting, and disqualifiers for prohibited persons still stand. What changes is the message. The gate is no longer residents only. The message becomes meet the objective criteria and step forward. That shift is more than paperwork. It is dignity restored. It says the Second Amendment belongs to the people, not to a zip code, and certainly not to an agency clerk with a residency checkbox. Direction matters, momentum matters, and the direction right now is toward equal access for qualified adults. Skeptics will grumble that these victories are merely procedural. That misses the point entirely. Procedure is power. The right to apply is the right to be heard, and the right to be heard is how lawful citizens carry without begging a border for permission. This is momentum, not a moment, and more courts are reading Bruen the way it was written. Stick with me because the next segment will break down timelines, training, and realistic expectations as this landscape settles into place. For tonight, celebrate the principle that finally roared back into the room: rights do not blink off like a porch light when you cross a county line. That is a real, measurable victory, and it deserves to be recognized with the same energy that carried these cases across the finish line. Picking up the surge of momentum, the core lesson from California is almost breathtaking. In its simplicity, a state can license public carry, but it cannot erect a residency wall that bars peaceable adults from even knocking on the door. That is why the Hoffman versus Bonta ruling lands with such force. It says the quiet part out loud rights are not souvenirs available only to locals. If a state invites residents to apply equal treatment, compels it to read non-resident applications on the same terms. That is fairness, and better yet, that is the Constitution speaking with both authority and common sense. This matters because the old script was pure defeatism. For years, the answer to a traveler's honest question, "Can I apply?" was a curt, mechanical no. Under the Bruen framework, the question flips from domicile to eligibility. Do you meet objective criteria that have meaningful historical support? Training, background checks, fingerprinting, and neutral disqualifiers remain on the table. What falls away is the lazy shortcut that a zip code determines your standing. Feel the difference in your gut. The gatekeeper's first glance used to land on your address. Today, it must land on your qualifications. Clarity also depends on clean definitions, and this movement thrives when language is precise. Reciprocity means one state recognizes another's permit. Constitutional carry means permitless carry for most adults who are not otherwise prohibited. Non-resident eligibility means a licensing state accepts applications from visitors and evaluates them neutrally. Hoffman only touches that third lane, and that is fine because opening the lane is exactly how real people start moving again. You still study the destination's laws, you still complete required courses, and you still carry where it is lawful. The victory is that the door finally opens. Consider what this signals for places with stricter frameworks. After Bruen, some jurisdictions redrafted their statutes, broadened sensitive place lists, and built out character reviews. Litigation has been fierce and sometimes messy, with injunctions issued, stayed trimmed, and reissued. Through all that churn, one theme keeps surviving: scrutiny. Blanket residency bars are exceptionally weak. Courts may argue over the edges of sensitive places, but the idea that a peaceful adult becomes ineligible the instant a highway mile marker passes is losing air fast. That is not a small tweak, that is a tectonic adjustment. Here is the practical heartbeat of the change. Non-residents should expect to meet the same benchmarks as residents: fingerprints, photographs, live fire qualification if required, and completion certificates signed by approved instructors. Budget for fees, schedule appointments early, and keep every receipt. None of this undermines the win. It amplifies it. The message is clear and exhilarating. Line up your paperwork, demonstrate competence, and expect the process to treat you like a grown-up rather than a trespasser. That is what equal access feels like. The national map remains a patchwork, but the seams are ripping where the fabric was thinnest. Each time a judge reaffirms that rights travel with the person, policymaking recalibrates agencies' revised forms, and lawmakers think twice before defending a dead-end barrier. Momentum is not a slogan. It is the steady drumbeat of courts demanding history, not hunches, and equal standards, not residency vetoes. The takeaway could not be more energizing. If a state chooses to license, carry the path cannot be locals only. That principle is winning in court, and the echo is getting louder. Picking up the thread, what makes this surge so thrilling is how timelines shape real outcomes. Agencies post appointment slots, training syllabi, and background check windows, and those clocks control everything. Plan 6 to 8 weeks ahead, finish the state's coursework early, and time fingerprinting close to filing, so results do not expire midstream. Documentation becomes part of the victory itself. Bring government identification, proof of address, signed training certificates, passport-style photographs, and any notarized affidavits the destination requires. Neighboring states often showcase the sharpest contrasts, which is exactly why these rulings matter. One jurisdiction finally opens a neutral lane for non-residents, while the next clings to sprawling, sensitive place lists that squeeze lawful carry into a maze. Treat each itinerary as a bundle. Transport rules for the route. Carry rules for the destination, storage rules for lodging, and a fallback plan when a venue posts prohibitions. A compact lockable case, a separate container for ammunition, can clear confusion during a traffic stop or a hotel check-in. Private property policies vary widely, so watch for signage, special event carve-outs, and employer restrictions that may require securing a firearm before entry. Every win that removes a residency wall stretches the map of freedom a little farther, and you can feel that stretch in simpler packing lists and calmer trips. Legal timelines deserve the same disciplined focus. Appeals stretch for months. Preliminary injunctions can be stayed, modified, or narrowed, and agencies do not always update forms the minute a ruling drops. A headline announcing a win is not the finish line, but it is proof that momentum is on our side. Smart travelers track dockets, look for final judgments, and confirm whether licensing offices have posted interim instructions. Avoid stepping into a gray zone between what a court has said in principle and what a clerk is implementing in practice. Zooming out to the national map, familiar themes keep repeating. Courts are increasingly skeptical of residency bans that block entire classes of peaceable adults from even applying. At the same time, neutral training, competence checks, and background screens continue to stand, provided they rest on solid historical footing and operate even-handedly. The most contested ground remains sensitive places where lines are still being drawn and redrawn. Legislatures respond by clarifying definitions, tightening disqualifiers for prohibited persons, and improving procedures so checks are accurate. Ranges and instructors are adapting as well, aligning lesson plans with state syllabi, adding legal briefings, and helping applicants avoid classic pitfalls that derail paperwork. Practical scenarios bring all of this to life. Picture a parent driving to help a college student move across state lines, a contractor rotating through short job sites, or a retailer delivering inventory to weekend fairs. Each used to face the same trap: the legal map shifted, and rights seemed to vanish at a county line. Thanks to these rulings, fewer people are being forced into that corner. Double-check official rules before leaving. Carry documentation proving training and eligibility. Transport firearms unloaded and locked with ammunition stored separately, and be ready to comply with posted restrictions without drama. Courteous, informed interactions tend to produce the best outcomes when questions arise. This has been a season of meaningful victories, not isolated flashes. Each ruling demonstrates that the clear constitutional standard works, that courts demand history rather than hunches, and that ordinary people insisting on equal treatment can reshape the landscape in real time. The direction is unmistakable, the drumbeat is steady, and the message could not be louder. Rights travel with the person. Thanks for staying through this deep dive. Share it with someone preparing a cross-border trip, and subscribe so you do not miss the next step as agencies post updates and the next round of decisions lands.